we focused more on what norms are there that protect environment in the time of international armed conflict. And today we will continue talking about those norms, but mostly talking of what happens in case when these norms are violated and what are the possibilities for responsibility for the environmental damage. And we will focus naturally also on the situation that we have here in Ukraine, in Ukraine where I'm not currently. So I believe by now you already know a lot about the situation and the damage that has been caused. And for some reason, I can't really move here to the next slide too. I believe I have to stop sharing it again and start sharing it once again. Maybe I just close the presentation altogether and then open it once again, and then it should start working. I'm very sorry for this. Now you should be able to see the second slide, right? Good, great. So the damage caused to Ukrainian environment has been already tremendous, and it continues to progress. Well, it was actually caused not only in this high phase of hostilities starting on the 24th of February 2022, but already since 2014, especially because the data and information about damage caused in the eastern part of Ukraine and also in Crimea under occupation was not really readily available. But in the potential compensation, we also have to take this into account. But from what has happened since the fully fledged aggression of Russian Federation, we can see multiple instances of air pollution, pollution to water, soil, also some destruction of plants within the cities that influence situation. So this damage has been caused not only by the weapons themselves, but also by the substances that have been revealed after certain infrastructural objects have been hit. On this picture, we can see how the fertile land was damaged tremendously, also constituting damage to agriculture. There have been numerous instances of forest fires. There have been destructions of protected areas in the eastern part of Ukraine, and sadly, lots of instances of death of dolphins have been reported. And one of the key difficulties with environmental damage, about which we will talk later on, is also lack of credible data, lack of baseline information, lack of monitoring of situation before the war, so that it's really hard to assess the scope of the damage being caused. But also when it comes to dolphins, for instance, scientists can only estimate the number of deaths of these creatures because it's only a certain percentage of them that are being thrown to the seaside, and some of them remain within the sea. So it's really hard to say the full number. And for instance, some data about particular species that was available to scientists is the information about the greater spotted eagles. On these maps, you can see the pre-conflict and during conflict sites where these creatures usually stop during their migration. So these are migratory species that stop in Ukraine in certain regions. And luckily, it's more or less closer to the western part, where the hostilities were not that harsh, but still, it was reported by scientists that because of the hostilities early in 2022, these greater spotted eagles had to change their migration routes, and they had to travel longer distances, which might have affected also the number of species that survived and that made it to the Nestor site in Polisia in Belarus. And in this way, the war directly affects also these creatures. These greater spotted eagles are species that are listed as vulnerable on the International Union for Conservation Nature Red List. So we can see that this information, this study shows that these species were subject to extreme anthropogenic disturbance, and they had to suffer during their migration from these facilities, even though it's unclear what exactly influenced behavior of these species, whether it's light or maybe it's air pollution or maybe it's noise, but scientists can attest to the fact that it already influenced that species in 2022. And now moving from biology and technical data, so to say, let's move to the legal information and the legal possibilities for responsibility. As most of you may know, there are two primary courses of action or modes of responsibility. First is the responsibility of a state for international wrongful act, and second is individual criminal responsibility, which might be undertaken in the format of international criminal court or some other kind of tribunal, or also maybe undertaken under national legislation, because also as we know that in most of the cases, national jurisdiction is in a better position to actually to hold people accountable at the large scale, and international institutions like International Criminal Court and exercise complementary jurisdiction in the situations where a state is either unable or unwilling to prosecute. And now let's move on to the responsibility of states for international wrongful acts. There are articles for the responsibility of states for international wrongful acts, codified and also partly progressively developed by the International Law Commission in 2001, and they were recommended by General Assembly, and they, as of now, are widely regarded to express customary rules of international law when it comes to the responsibility of states. And they also codify the key principles of responsibility, that is, that the full reparation for the injury caused by international wrongful act shall take form of restitution, compensation, and satisfaction, either singly or in combination. And this is enshrined in Article 34 of these articles. Maybe someone knows what these three concepts mean: restitution, compensation, and satisfaction. If you know, feel free to raise your hand and comment. And if not, I will continue, saying that restitution is a primary mode of reparation, and it means the reestablishment of the situation which existed before the wrongful act was committed, provided and to the extent that it is not materially impossible and that it does not involve a burden out of all proportion to the benefit deriving from restitution instead of compensation. So it means that in most cases, whenever restitution is possible, it should be used, because it means reestablishment of the situation as it was before the violation. But as we may assume in environmental matters, sometimes it's really hard to apply this mode of reparation, because it's actually impossible to restore fragile forest ecosystem that has been destroyed, or revitalize endangered species that became endangered because of the conflict. So in environmental matters, as the experience shows, compensation is more widely used. And compensation is meant to be there in the cases where the damage is not made good by restitution. The compensation shall cover any financial assessable damage, including loss of profits, insofar as it is established. One of the challenges that may easily come to your minds as you listen to about compensation now is that actually how to calculate the damage caused to environment, how to put it into the framework of numbers, because it might be so complex and so multifaceted. For instance, on the example of forest, one may think that maybe one way to calculate damage caused by war to the forest is to calculate the price of the timber that might have been harvested from that forest. But that would be only a tiny proportion, because the forest actually exercises lots of ecosystem functions, such as water purification or erosion control, or also purification of the air. And that's why the mode of calculation, the methodology of how to come to the number is really complex, and it has to be established on a case-by-case basis to with respect to different areas that were damaged because of the war. And the third mode of responsibility is satisfaction. It means kind of political recognition of the action of a state, and satisfaction is used insofar as the wrongful act cannot be made good by restitution or compensation. Satisfaction may consist in acknowledgement of the breach, in an expression of regret, a formal apology, or another appropriate modality. And satisfaction shall not be made in a way that it will constitute a humiliating form to the responsible state. Now, I also mentioned last time, as I believe everyone remembers, the challenge when it comes to international environmental law and international humanitarian law, that the damage actually protected by the international humanitarian law is subject to this very high threshold of widespread, long-term, and severe damage. However, in practice, sometimes, as we will see later, this threshold is kind of not fully disregarded, but there are modalities of how to still receive the compensation regardless this high threshold. This was, for instance, done partly by the commission established to provide compensation as a result of the 1990-1991 Gulf War. And also in the Eritrea-Ethiopia Claims Commission. It was possible not to use this high standard of high threshold of widespread, long-term, and severe damage. But on the other hand, this standard was used, for instance, in the report of the committee established to review the NATO bombing campaign against the Federal Republic of Yugoslavia. And in the 2000 report, it was stated that the damage to the natural environment caused by NATO bombing campaign in Kosovo did not reach the threshold of widespread, long-term, and severe. And the damage was reported to have included pollution at a number of sites, which was serious and posed a threat to human health, but did not affect the Balkan region as a whole. And that's why it was not considered to be widespread. And now let's move to another precise example of how how state might be held accountable for the violation of environmental protection norms during the armed conflict. Maybe many of you might know better than me the context of that situation, of that conflict between and occupation of the territory of the Democratic Republic of Congo, which resulted in the case concerning armed activities on the territory of the Congo, heard by the International Court of Justice, or ICJ. And here I put two numbers, 2005 and 2022, because in 2005, the court issued or released the decision on merits. and in 2022 there was a decision on reparations. In that decision, court once again summarized or relied on its previous practice also in other cases with respect to the responsibility of state for the damage caused to the environment. For instance, it stated that the court observes that it is well established in general international law that a state which bears responsibility for an international wrongful act is under an obligation to make full reparation for the injury caused by that act. In its 2005 decision, the court indeed found the violations of various provisions of international law, including illegal use of force, violation of sovereignty and territorial integrity, military intervention, occupation of part of Congo called Ituri, violations of international human rights law and of international humanitarian law, and various other violations. And one of the elements among all of these violations and also claims for reparations was the damage related to natural resources. In particular, it concerned extraction of minerals, also damage to flora, including exploitation of timber and also coffee trees, damage to fauna, especially in Okapi Wildlife Reserve and other natural parks. And as a result of this reparation, the court awarded global sum of over $60 million US dollars as a damage for natural resources. And also about several standards that the court used. It also stated, for instance, that it is consistent with the principles of international law governing the consequences of international wrongful acts, including the principle of full reparation to hold the compensation is due for damage caused to the environment in and of itself. So we see that the court confirmed here that the damage to environment itself is something that could be compensated. And also what is important for future cases is despite the court awarded this huge sum of compensation, it did not satisfy all of the claims of Congo. And one of the claims that was rejected was about the deforestation, because Congo did not provide the court with any basis for assessing the damage to biodiversity through deforestation. And even though the court stated that there might be difficulties to present evidence, and this is understandable because of the situation of the conflict, but still there is this need to demonstrate sufficient causal nexus, and the court can also evaluate it on the case-by-case basis, but still there has to be certain evidence, and there has to be a certain methodology of how this was calculated. And therefore, maybe one of the tasks also for Ukraine here, which Ukraine is already working on, is to collect evidence and to come up with a sound methodology of calculating damage to environment. Another example of successful compensation for the damage to environment in case of armed conflict is the United Nations Compensation Commission that I already mentioned. This commission was created in 1991 as a subsidiary organ of the Security Council. So we see that in the situation of Ukraine, it's rather impossible, this mode of creating certain body, because we know that the Security Council is a bit blocked by Russian veto and Chinese veto potentially. But still, that commission is considered to be an important example for Ukraine, and Ukrainian government is now or has been working hard on establishing a similar body, which is partly established and about which I will say later on. But what is interesting about this compensation commission is that it has been working actually for quite a long period of time, from 1991 till 2022. So in January 2022, it was decided that this commission has complied with all of its tasks, and it concluded its work. And during this time, also over 2 million claimants submitted their claims for compensation, and approximately 1.5 million claimants were awarded the compensation, actually, which was over 52 billion US dollars, and the part relating directly to the environmental damage constituted over 5 billion of US dollars. And the current mechanism that is being created by Ukraine in cooperation with the Council of Europe is the register of damage caused by the aggression of the Russian Federation against Ukraine. I believe you might also have heard of this mechanism. I think initial discussions about some kind of mechanism also emerged early in 2022, but at that point of time, it was still uncertain how it will function. And gradually, this register was created. It is designed to function as a record of all eligible claims seeking compensation for damages, losses, and injuries inflicted by Russian aggression in Ukraine. And it will also contain supporting evidence for these claims. It was actually launched a bit earlier this year, several months ago, and it has its seat in The Hague. For now, the task of this register is only to gather these eligible claims and gather information. And as of now, it also receives claims only within one narrow subcategory, and that's category A3.1, damage or destruction of residential immovable property. So as of now, it does not collect information about environmental damage as such. And overall, there are numerous categories of claims that it is supposed to start also registering later on, including claims from citizens, claims from like the physical persons, claims from business entities, and claims from Ukraine as a state. And as we can see in the documents on this register, within the category B, claims by the state of Ukraine, there is a category B3, damage to environment and natural resources, which has two subcategories: environmental damage and depletion or damage of natural resources. So in future, it should also be possible for Ukraine to use this mechanism to actually hopefully later receive compensation, even though as of now, the task of this register is just to register information, to collect all the evidence and all the materials, and the mechanism of compensation itself has not been yet created. So there is still a need for further negotiations and for a format which would be acceptable for the international community and Ukraine to compensate maybe some frozen assets of Russia, and certain individuals from Russia may be used, but this is all not settled yet. What Ukraine also does, I believe also partially for the purposes of filling later the claims within this register system, Ukraine asks everyone within its territory to collect information about damage to environment caused during the war. And it could be done through two platforms. One of them is an app called Ecology, and the second is platform Svidok.org. And all of these technical possibilities were also created quite recently. But the Ecology is also a web page which provides comprehensive data about the current state of damage being caused to Ukraine. And on this page, we can see, on this slide, we can see that 5,298 documents were submitted. So there are over 5,000 recorded facts about damage to environment already through these instruments. And there is a calculated also amount of loss in hryvnia on this slide, even though it is, I haven't found the precise methodology of as to how it was calculated, but the state environmental inspection is in charge of calculating all of this environmental damage and keeping the track of the current numbers. And here you can see how this EcoZagroza app is looking like. So you may, if you have a chance to be in Ukraine and to witness damage to environment, you can also use this resource, probably. So, and this mechanism might be indeed, coupled with this register and then the compensation mechanism that might be created later, this could in fact be efficient in terms of trying to receive the compensation, even though, as I mentioned at the very beginning, compensation is or might not be the best way, because ideally the situation has to be restored the way it was. And also the challenge with compensation is a bit how to also how to control the way the money that came through this compensation mechanism for environmental purposes is indeed used for revitalization of the ecosystems. And also one of the challenges might be to think what environmental restoration might entail indeed, whether it's maybe just primarily restoration of functions of the ecosystem or restoration of certain features of the landscape. So it's also subject to a discussion how exactly then the ecosystems have to be or could be restored. But now we will turn to another segment of responsibility, which is different from the responsibility of a state and which is different from the compensation. And this is the individual criminal responsibility. And individual criminal responsibility means that unlike state responsibility, where we have an abstract entity state, which can compensate or restore something or make satisfaction, here we have responsibility of individuals that were exactly in charge of performing certain actions which amount to violations of international criminal law, for instance, or to violation of domestic criminal law of a certain country, in this case, Ukraine. And as we can see on this slide, the Rome Statute of the International Criminal Court actually contains one article among the war crimes. There is section 2b4 in Article 8, which reads that intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects or widespread, long-term and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated, constitutes a war crime. You may have already noticed that it uses the same wording as the additional protocol 1, about which we talked last time at length, and it uses this widespread, long-term and severe damage standard. But also on top of that, the requirements of the Rome Statute are even more stringent, because it also uses the word intentionally. So not only the damage has to correspond to these criteria of widespread, long-term and severe, but also the intent of perpetrators has to be proven in this case, which might be challenging, and which you might have read about in the report that I shared with Father Roman about the Kakhovka dam destruction. So here, the knowledge of the potential consequences has to be also proven. And also, when we talk about Ukrainian criminal code, there are two articles that I also mentioned last time. One of them is Article 438, about violations of rules and customs of war. for which in the case when this is, but it actually does not directly prescribe environmental consequences to the environment. It is quite broad and general, but in theory, the sanction for this article is imprisonment between 8 and 20 years. And if it led to the intentional killings, then it also may be from 10 to 15 years or lifetime imprisonment. And also we have Article 441, ecocide. And for this article, we have the sanction from 8 to 15 years also of imprisonment. Now, small case study, which I also shared with you, or not too small, because that document, I'm not sure whether you received it. Maybe Father Roman can say it, whether participants had a chance to take a look at this report in advance, but it's quite comprehensive. It explores the context, the situation before this event, and also how it influenced populations residing in this area, and also wider environment within the territories where the Kakhovka Reservoir was located, but also this impact on the Black Sea. And on these pictures, you can see also the data with 1 month of difference. The above picture shows the data as of 5th of June, so 1 day before this event of 6 June 2023, where the dam was blown, and then all of the water started to to go downstream and then to the Black Sea. And the picture below shows the picture as of 5th July 2023, so exactly 1 month after the situation with the blowing of the Kakhovka Dam. And this light blue color shows the area drained within this 1 month. And as of now, the situation continues to evolve. This year, many governmental and non-governmental organizations also published the reports of assessment of 1 year later, how the landscape changed and how it influenced the ecosystems. But the key adverse impacts involve the adverse effects on the water, and also on the huge system of irrigation in that area, because the water from the dam was used to water the crops in this region, and also it influenced the water quality and sanitation of residents. Also the detrimental impact on flora, fauna, and natural reserves located in the vicinity of this area, harmful influence on soils, and also generally the balance of the ecosystems surrounding this area. So also this impact of the blowing of the Kakhovka Dam is really disturbing. And the consequences include, for instance, also the impact on the ecosystems of the Black Sea, resulting in the desalination of its waters. And also the key challenge in relation to the standard applied to the violation of international humanitarian law is also this, again, the widespread, long-term, and severe damage. So the authors of the report that I shared from the NGO Truth Hands in Ukraine claim in that report that the blowing up of Kakhovka Dam does amount to this gravity threshold, and also amounts to the threshold set by the Rome Statute of International Criminal Court, saying that this element of intent is also established here. And also, as a result, they have the call to action. Firstly, they call to action the office of the prosecutor of the International Criminal Court to take a closer look at this situation, even though they are aware that the office of the prosecutor is already also investigating this situation. But as of now, there is no publicly available information on the webpage of the International Criminal Court, whether it considers also the violation of the Article 8 of the Rome Statute with respect to environmental damage. We only have their alleged violations and also arrest warrants with respect to attack against civilians and civilian objects, also covered by the same article. And also, they call in general for the greater attention to this particular situation, to ensure the restoration of justice for that region that suffered from the violations of the international humanitarian law, and also which is regulated by the international criminal law. That's it when it comes to the key information, and maybe if you have questions, we can discuss them, or maybe we can also discuss some general matters relating to perhaps violation to the valuation that was used in other cases, or maybe also certain elements where the environmental damage is also not assessed only as environmental damage, but in close relation to the damage to public health, for instance. Yeah, but for now, that's it, and thank you for your attention.